Thank you for waiting. We will now begin the panel discussion. First, I'd like to introduce the panelists. Japan IPHC Chief Judge Otaka Ichiro, IPHC Judge Kobayashi Yasuhiko, Attorney at Law, Oebashi Law Firm, Shigetomi Takamitsu, the Intellectual Property Court of Beijing, Judge Liu Yijin, India High Court of Delhi, Honorable Justice Pratibha M. Sin, Republic of Korea Patent Court of Korea, Presiding Judge Sang-woo Kim. Next, I'd like to introduce the moderators. Japan IPHC Judge Nakajima Tomohiro, Attorney at Law Abe Ikubo, Katayama Law Firm Hattori Makoto. The panel discussion will be held with these members. I'd now like to ask the two moderators to lead the discussion from now, Judge Nakajima and Mr. Hattori. The floor is yours. Ladies and gentlemen, this panel discussion will be divided into two parts. The first part deals with indirect infringement based on mock trial case, and the second part deals with the use of expert knowledge in civil litigation. Today, we have judges from China, Korea, and India joining us online. I'd like to express my sincere gratitude to all of you for taking time out of your busy schedules to join us. First, allow me to briefly review the concept of indirect infringement, just to be clear. Patent infringement refers to a case where a person works on invention that falls within the technical scope of the patented invention without legitimate authority, and this is called direct infringement. The technical scope of a patented invention is determined based on the description of the claims. So, for example, if the patent is for the invention of a product, whether the sale of the product by a person constitutes direct infringement or not is determined by whether the product satisfies all of the features described in the claims. On the other hand, if the product satisfies only a part of the features, the sale of the product is working of only a part of the patented invention, so direct infringement is not established, but certain acts that have a high probability of inducing direct infringement are regarded as acts of preparatory and contributing nature for infringement, and are referred to as indirect infringement. Indirect infringement is an issue not only in the case of the invention of products, but also in the case of inventions of methods and the methods of producing products. This time, we will basically deal with indirect infringement of inventions of products. Indirect infringement is treated differently under the laws of each country. The Japanese patent law has provisions on indirect infringement, and there are two types of indirect infringement. One is called exclusive use type, and the other is multi-use but indispensable type. China and South Korea also have certain provisions on indirect infringement, although they differ in terms of content. In India, there is no statute that provides for indirect infringement. In the mock trial of Japan, only the defendant's stylus was found to be indirectly infringing as a non-exclusive product, and an injunction against its manufacture and sale was awarded. We sent the mock trial case to the judges in China, Korea, and India for their consideration in advance, and their responses were as follows. Judge Liu of China and Judge Kim of Korea admitted the existence of indirect infringement only for the defendant's stylus as an exclusive product and granted an injunction against its manufacture and sale. Judge Sin of India pointed out that although patent infringement was not basically established, direct infringement could be established depending on the specific circumstances. We will examine the legal frameworks of each country and the judgments in the mock trial case in turn. First, Mr. Otaka will explain the key points of Japan's decision.
それでは日本の判断
I'd like to explain about the Japan's judgment. Please take a look at the slides. When claiming indirect infringement of a patent for an invention of a product, it's first necessary to specify the form and manner of the act that constitutes direct infringement. In this case, well, we're talking about the transfer. In this case, the plaintiff claims that the position detector in the form beta, where the defendant's stylus is attached, belongs to the technical scope of the invention. So you remove the standard stylus and then you attach the defendant's stylus, and the act of that would be production. Then you attach it to the machining center, and then you would process the various work pieces, and that would be direct infringement. So the plaintiff can ask for injunction directly to the user, but if you think about the actual world of transactions, in terms of the plaintiff, where that kind of user exists that is conducting the direct infringement, finding that will be very difficult. So they are requesting an injunction against the defendant that the manufacture and sale of the stylus and position detector constitute indirect infringement. In Article 101 of the Patent Act before amendment in 2002, there was only items 1 and 4 in the current one. It was limited to indirect infringement to things used exclusively for the producing of the thing. This exclusivity requirement was established to prevent unjustified expansion of patent rights, because if objects that can also be used for other purposes are included in the scope of indirect infringement, acts that do not constitute patent infringement may also be considered as infringement. However, on the other hand, cases in which the requirement of exclusivity is not satisfied simply because there are other uses and non-infringement would be found was considered to be a problem. So, in order to strike a balance between the need to ensure the effectiveness of the patent right and the need to prevent unreasonable expansion of the patent right, the Patent Act was amended in 2002 to maintain the exclusive product type of indirect infringement and to relax the objective requirements, while at the same time setting up a new category of indirect infringement of the non-exclusive product type with the subjective requirements that they know the invention is a patented invention and the thing is used for the working of the invention. And thus the scope of indirect infringement was expanded. So the red part are those requirements. And explain the manufacture and sale of the defendant's stylus. And at issue is the position detector with the defendant's stylus. So whether the defendant's stylus is used exclusively for the producing of the position detector in beta form. It's 101.1. So exclusively or used solely means that it is used only for the purpose of the patented product. And the plaintiff has the burden of proof. So in order for it to be exclusive, doesn't mean that there's absolutely no possibility it will be used for other uses. So how is it handled? The other uses asserted by the defendant, the plaintiff needs to prove that it is not economical, commercial, or practical based on social norms. And this stylus, defendant's stylus, as was shown in the mock trial. So, well, the defendant has two position detectors on which it can be used. One is the energized type, the other is the internal contact type. Next slide, please. And this shows the scope, and the blue part. So the when coming in contact with the workpiece, the closed circuit is formed, and the detector detects that current. And so the left-hand side one that is within the scope, but the right one, the internal contact type detector, doesn't meet the feature A. And so, for example, a user from the defendant buys the internal contact type and energized type, one each, and uses both types of detectors. And this stylus is being used for the internal contact type as a replacement part. Then that would be out of the scope of the technical scope, so it would not be direct infringement. The internal contact type, using it for the internal contact type, that is a practical use, and so as a result, so this is a replaceable part that is compatible with both types of detectors, and so it is a practical use. However, and you cannot say that it is not economical, commercial, or practical, and plaintiff has to prove otherwise, and so it is not something that is exclusively used for the production, and so the direct infringement based on 1011 would not stand. Now, based on 101.2, multi-use type infringement. So, is it essential or indispensable for the resolution of the problem by invention? That's the keys. And indispensable to the solution of the problem means that by using that, and only by using that, you can solve the problem. And we're talking about the component or material that allows that to happen. So it has to be related to the problem-solving principle of the invention. And so that would be the essential feature, put it another way. And so how do you judge whether it is related to the solving of the problem? So based on the specification and the scope, you look at the issue that is to be solved, what are the means for that, and you look at the technical significance of the invention in terms of the effect, and you judge whether this is related to the problem-solving principle of the invention. And the problem-solving principle of this invention here is as written. Well, it's from 0.6 to 0.10 of the specification. And next, this stylus. Well, what about this stylus? As you just saw, in terms of the problem-solving principle, well, for the energized type detector, the contact part is made out of tungsten carbide and nickel binder, and it's non-magnetic, so that's the problem-solving principle. And so that is identical to the structure of the patent, so it is essential for solving the problem. And the other requirement, widely distributed in Japan, that it is not widely distributed, that's the requirement. And this stylus for the defense, it can be well, it's a special customized product to be attached to the defendant's detector, and so it is not a standard popular product, and so it would not be widely distributed in Japan, and so non-exclusive use indirect infringement can be found. Next, about the subjective requirement as written in item 2, whether or not you knew the invention is a patented invention and whether you knew it's used for the working of the invention in selling that product. And as was seen in the decision and in the mock trial, the defendant received a notice from the plaintiff and learned that it's a patented invention and that the defendant's stylus highly likely to be used to practice the invention, and so that meets the subjective requirement. And so objective and subjective requirements both are fulfilled, and so non-exclusive type indirect infringement is found. And so looking at whether detector is direct or indirectly infringing. So when you think about the significance of the technology, the issue to be solved or the principle for solving is that you have the tungsten carbide and a nickel bind non-magnetic material in the stylus. And the detector is a separate component from the stylus, and so this detector is not essential for solving the problem. It's not indispensable. Therefore, so the manufacture and sale of the detector does not meet the requirement of item 2. So non-exclusive indirect infringement does not stand for this. And next, about the necessity of injunction. And so this is compatible with other type of detector and can be used for the internal contact type. So before the user uses it, to have an injunction would also restrict lawful use and will prevent the lawful use, and that would maybe excessive injunction. So they're claiming that it's not necessary, and so the point of judgment is this stylus. Well, the standard stylus is attached to the detector, and this is being sold as a replacement part, and so most of the users naturally would buy this to use it for that detector, and the probability of the infringement is high by transferring the stylus, and therefore there is a need for an injunction to stop or prevent the manufacture or the infringement. And so injunction against the manufacture and sale of the stylus is justified because there is indirect infringement, but the request for an injunction against the manufacture and sale of the position detector is groundless. That's the explanation for the Japanese judgment.
小高社長ありがとうございました。
Thank you very much, Mr. Otaka. We'd like to move on to China.
Hello, Judge Liu. Now,
Hello.
could you please elaborate the legal framework for indirect infringement of a patent right in China, and then your decision on the mock case?
Okay, thank you. It's my great honor in this symposium. The patent law of China covers only direct infringement. There's no provision regarding indirect infringement of patent right in the patent law. Indirect infringement of patent right is determined based on the interpretation 2 by the Supreme People's Court on several issues, and Article 1169 of the Civil Code. The Civil Code 1169 provides one who abets or assists another person in committing tort should be liable jointly and severally with the tortfeasor. The first paragraph of Article 21 of the Interpretation 2 by the Supreme People's Court provides When the party knows clearly that an involved product is a material, an equipment, a component, or an intermediate, and so on, exclusively used for exploitation of a patent, nevertheless provides such product for the purpose of production or business management to a third party implementing an act of infringement of patent, a competent people's court shall uphold the claim by the right holder that the action of such provider falls upon an action of assist another person in committing a tort, provided in Article 1169 of the Civil Code. Requirements of the first paragraph, Article 21 of the Interpretation 2 are as follows. The objective requirements include, firstly, the involved product is a material, an equipment, a component, or an intermediate, and so on of patented product. That's to say that the involved product is only part of the patented product. Secondly, the involved product should be exclusively used for exploitation of the patent. That's also to say that the involved product can't be a standard or popular product. Thirdly, once a third party uses the involved product, the patented invention is implemented, but it's not indispensable that the third party has actually implemented the patented invention. As long as there is a high probability, it's enough. Fourthly, it should be for the purpose of production and business management. Fifthly, the subjective requirement is that the defendant knows clearly all of the above. The second paragraph of the Article 21 provides when the party knowing clearly that a patent right is granted for an involved product or method without any lessening from the patentee, nevertheless induce actively a third party to implement an act of infringement of the patent for purpose of production or business management. A competent people's court should hold the claim by the right holder that the action of such inducer falls upon an action to abet another person in committing a tort, provided in Article 1169 of the Civil Code. The requirements of the second paragraph, Article 21 of the Interpretation 2 are as follows. The objective requirements is, firstly, the defendant has implemented an act of induction. Secondly, it should be for the purpose of production or business management. The subjective requirements include, firstly, the purpose of the defendant is to make third party to implement the patented invention. Secondly, the defendant knows clearly that all the third party do is an act of infringement. As to the decision on the mock case, according to the patent law of China, the reason for the involved status to constitute indirect infringement include, firstly, the exclusively use as stipulated in the first paragraph of the Article 21 of the Interpretation 2 shall be determined by the criteria whether the alleged involvement, the alleged component, etc., has substantial meaning for implementing the technical solution of the present patent. That is, if the corresponding component is indispensable for implementing the technical solutions of the present patent and doesn't have another substantial non-infringing use, alleged component, etc., shall be determined as exclusively used in general. Also, the involved status can also be used for the internal contact type, but not the substantial non-infringing use according to Chinese law. The criteria is, generally speaking, substantial non-infringing use must comply with the principle of economic benefit and be practically or feasible. If product objectively has another use, but the use is not commercially or economically practical, or the use reduces the value of the product, or is only a part of the idle function of the product, the court usually determines that the use is not substantially non-infringing use. Maybe this explanation is a little more broader than the scope of the Japanese law. In this case, since it involves stylus not commercially or economically practical to be used for the internal contact tab, we can reasonably predict that almost all the users would attach involved styluses to the NGS tab position detectors. So it can be regarded as a product that is exclusively used for the patented product. Secondly, the defendant's position detector informed bit fulfills all the elements of the present innovation and fall within its technical scope if a user who possesses a defendant's position detector attaches a position stylus to the defendant's position detector. Such an act by the user should be considered as a production of the product. Regarding to a defendant's position product in alphabet inform bit that falls within the technical scope of the present patent. Thirdly, the defendants know clearly that as long as the defendant's stylus is attached to the position detector he has sold, all the technical features of the patented invention would be fulfilled. In China, it's not necessary that the third party must have actually implemented an act of infringement of a patent according to the Article 21 of the Interpretation 2. Also, in practice, the court has refused to determine that the indirect infringement is established because the patentee has failed to improve the existence of the direct infringement. However, when the direct infringement can be reasonably expected or predicted, the court will usually directly determine that direct infringement has occurred without the plaintiff's proof. So the injunction against the manufacture and sale of the defendant's stylus shall be admitted in China without limitation. The legal basis is the Article 179 of the Civil Code. Civil liability shall be assumed primarily in the following manners. First, cessation of infringement. On the other hand, I found the manufacture and sale of the defendant's position detector by the defendant doesn't constitute infringement on the present patent. The reasons are mainly as follows. To establish direct infringement in China, the involved product shall fulfill all the technical features of the patented invention. In this case, it's obvious that defendant's position detector only fulfills one feature, so it doesn't constitute direct infringement. Also, the present invention solves the problem of stylus being magnetized in the conventional NGS type position detector by making stylus of non-magnetic material, with only standard styluses attaching to the standard equipment. As the fact shows, defendant's position detector don't prevent measurement error caused due to the stylus wear deformation or magnetization caused by repeated contact with and separation from the workpiece and the line. So that's all my answers. Thank you.
Thank you, Judge Liu. Now I have just one question to clarify your explanations. I would like to ask about the concept of exclusively used as stipulated in the first paragraph of Article 21. As far as I understand, is it right to understand that you said the criteria is whether the alleged component has substantial meaning for implementing the technical solution of the patent, right?
Yeah. Yeah.
And you said whether it has substantial meaning or not shall be determined by two elements. First, the alleged component shall be indispensable for implementing the technical solutions of the patent. And second, it does not have another non-infringing use, which is substantial. Is my understanding correct?
Yes, correct.
Thank you very much for your explanation.
You're welcome.
Okay, so next, let's move on to Korea. Hello, Judge Kim. Could you please elaborate the legal framework in Korea and then your decision on the mock case?
Thank you, Nakajima. I will try to make the best possible use of 8 minutes allocated to me. I'd like to go through with you about legal framework in Korea with some PowerPoint slides. Let me introduce Article 120. The Patent Act prescribes an act deemed referring to an act that does not practice all elements of patent invention is likely to lead to result. It's written as direct infringement. The requirements for direct infringement under Article 127 on indirect infringement shall be used to protect the patent invention. It shall be exclusively used to practice the patent invention, and it shall be used for business purposes. In order to meet the first requirement, it is necessary that if a third party uses the indirect infringement act, it shall constitute patent invention. In addition, the production Article 127, first paragraph, that encompasses any act of creating having all elements of using the product of only part of the element of, and the concept is not limited to industrial production but also includes other acts such as processing and assembly. As for the second requirement, indirect infringement subject shall be exclusively used to practice patent invention. There is another use other than practicing the patent invention. Whether the subject is indirectly infringing shall be determined depending on whether it is an economic, commercial, or practical practice by social law research. In theory, theoretical, experimental, or temporal use. In practice, often the patentees intent on indirect infringement. The infringer makes a sound argument on the possible uses of indirect infringed subject, other than practicing the patent invention. And then the patentee is required to show that the use is not economical, or practical. As to the third requirement, a private or household act or an act of research or testing for purpose of research not constitute indirect infringement, even if it satisfies other requirements. Meanwhile, if an act is in the line of business, it is for business purpose, even if people engages in non-making business. Moreover, a one-time act is enough to meet the requirement and is productive, continuous, and repeated manner. I'd like to add a subject requirement. Article 107 of the Act subject requirement. Article 103 of the Patent Act provides presumption of negligence for direct infringement. This extends to indirect infringement Therefore, the indirect infringer shall rebut the presumption of infringement. Now, next slide, I would like to explain how I had made the decision. You can see from this slide, the defendant stylus indirectly infringe the patent invention at issue. The patent invention of this case is the product invention. There is no requirement, which is the dependent style shall be produced for the first. Dependent style is the first requirement and the second requirement. That dependent stylus was used only for the production of the patent invention. Meanwhile, the willfulness of the infringer is not requirement for the establishment of an indirect infringement under the Korean Patent Act, but negligence of indirect infringer is presumed. As to the question whether the dependent stylus satisfies the requirement, the dependent stylus is attached to the end position detector and or is used for it. Therefore, the position detector of the patent invention can be newly produced as a final product by attaching it to the dependent stylus. As the dependent position detector is own beta. Thus, the dependent stylus was used to produce the patent invention. This next slide provides an outline of the figure of where the dependent stylus satisfies the patent stylus. Even though the dependent stylus is a consumer's part, then indeed one or damaged over time. This is exclusively used for the production of the patent invention. I can list 5 reasons for this. First, the dependent is an essential element of the patent invention. Second, the dependent style is used for the patent invention. And third, dependent style is a product that cannot be easily obtained in general. Fourth, the great amount of comfort is predicted at the time of the patent product. The patentee has separately been manufacturing and preparing that component. This is the end of my presentation. Thank you.
Thank you, Judge Kim. Actually, we have some trouble in voice, so I would like to confirm the point. Now, I'd like to ask you in Japanese. Actually, let everyone know that you are a good Japanese speaker. Kim 裁判官.
So, Judge Kim, can you hear? I can hear you. So I want to confirm some points. So the defendant stylus, whether or not it is to be used for the defendant's detector only. So economically, commercially, and practically, is it feasible? Is what the point of the judgment? Yes. And the last slide that you showed. So in applying the mock case, you gave 5 reasons citing a Supreme Court decision that it's an essential element, or that is it used exclusively for the patent in question, And is it a product that can be easily obtained? Is a replacement predicted? And also, the patent owner, did it sell that separately? So 5 reasons were mentioned. So those 5 circumstances, so it's used to judge whether it's used only for that patented product, or is it more generally applied. The 5 requirements of the Supreme Court so is for the case where it's a consumable that's replaced often. It's not a general requirement. So frequently replaced consumable. Why is it that you take into consideration these 5 factors for those consumables? Well, consumables, they're necessary to use that, but it's not necessary to produce that product. So consumable, just being the exclusive is not enough. But in addition to being it used exclusively for the product, if there are 4 additional factors, then they can be judged to be those that are exclusively used to produce that product. So you take into consideration those circumstances for that. Yes. So thank you, Judge Kim. Thank you.
Now let's move on to India. Hello, Justice Sen. Thank you for waiting. We know there is no legal provisions stipulating indirect infringement of a patent right in India. So could you please explain more generally the legal framework for patent right infringement in India, and then your decision on the Maku case?
A very good afternoon. Thank you, Nakajima-san, for your introduction and for moderating this session so patiently. And thank you, Japanese IP High Court, for inviting me today. Nakajima-san, as you said, Section 48 of the Patents Act, Indian Patents Act, only provides for direct infringement. There is no provision relating to indirect infringement. As per Section 48, if the subject matter of the patent is a product, then the third party who is indulging in manufacture, use, sale, or import of that product will be infringing. That product here refers to the whole product. It does not refer to part of the product. If the manufacture of a single or multiple part by itself would not become infringement unless they are assembled together and sold as that product, which is the final completed product. But there is one exception to this, and that is if there is a main claim and the parts of the product are dependent claims separately, then that product under Section 48 for these claims would be even a part or a component. So, this patent, there is no dependent claim. Such a claim for the part or component, if granted, once it is established that the part is itself novel, inventive, and capable of industrial application, then in its own right, the part can be separately an infringement. However, in the absence of a separate claim for any of the components or the parts, the mere manufacture or use or sale of a component would not constitute infringement. This principle is also recognized in Section 10(4)(c) of the Indian Patent Act, infringement would be established only when the entire product performing the function as described in the claim as a whole is manufactured, sold, used, or imported by a non-authorized party. There is only one judgment where reference is made to indirect infringement in USA and UK. However, there is no finding or any case law in India on indirect infringement of a patent right. As a judge in the last 4.5 years, I have not come across any specific case on indirect infringement. Next slide, please. In the facts of this case, whether the manufacture of the stylus would be infringement or not, according to me, the claims of the patent in the present mock case has 5 elements. Thus, the patent granted is for a composite position detector consisting of all the 5 elements. That is the stylus, the main body, contact between stylus and workpiece, contact portion of the stylus remaining in contact with the workpiece, forming a closed circuit, and that stylus being a non-magnetic material stylus. There are no dependent or independent claims separately for the workpiece or for the stylus. The mere standalone stylus having a contacting portion made up of non-magnetic material without the position detector of which it is a part would not infringe the patent which is granted. Therefore, in my opinion, the mere manufacture of a non-magnetic stylus containing tungsten carbide and a nickel binder by itself on a standalone basis would not infringe. The position would have been different if there was an additional claim to the following effect. Suppose there was a claim in this patent which said a stylus having the contacting portion made up of a non-magnetic material composed of tungsten carbide and a nickel binder, capable of being used in a position detector as claimed in claim 1 to form a closed circuit, then this claim could have been infringed. The fact that the position detector may be sold with 2 styluses, namely an SUS stylus and a stylus of tungsten carbide, would not change the answer. It would be immaterial at what time, under what circumstances it is replaced, as long as the latter stylus is available for the use right out of the box of the user, even as an alternate. If there is an alternate use for the stylus, if the defendant is selling the stylus as a standalone product capable of being used exclusively, then it could be argued that there is direct infringement, as the only purpose of the defendant's stylus is for using the same in the position detector. The additional fact that there is a unique fitting mechanism which fits the stylus in the position detector could be a factor to hold in favor of the infringement. If the court finds that the sale of the defendant's stylus separately is only a trick, it is only a trick to escape infringement, the court could hold that there is direct infringement if there is exclusivity of the application of the stylus. If the defendant's stylus has multiple uses for application on different devices, then the mere manufacture of the stylus would not constitute direct infringement. If the manufacture and sale of the stylus is only for the purpose of position detector, it would be infringement. As per 108 section of the Indian Patent Act, one of the reliefs in a suit for infringement is an injunction. The court would then word the injunction in a manner that infringement would occur when the stylus is manufactured and sold for exclusive use in the position detector of the defendant. Thank you.
Thank you, Justice Sen. Now I have some questions to clarify some of your explanation. You said you have never come across any case involving indirect infringement. I'm curious about that. How do you think about the possibility that indirect infringement will be introduced in India through an adjudication on an appropriate case as a case law?
Okay, I think that indirect infringement is possible only when there is exclusive use of a part for that product itself, because there is no dependent claim. If there was a dependent claim, then there is direct infringement. If there is no dependent claim, there can be direct infringement if it is for exclusive use. Indirect infringement is not there in the statute, so it will only be by means of an interpretation.
My question is, so how do you think the possibility in the future whether the concept of indirect infringement will be introduced into India through case law or not, or just by statute? How do you think?
I think for indirect infringement to be considered separately as an act of infringement, it will require an amendment in the statute. Though I do agree that in case law, if there is exclusive use of a part for a product, there can be direct infringement.
Thank you very much. Okay, so now we have seen legal frameworks and decisions of all countries. So in short, 3 countries, China, Korea, and Japan, determined if the defendant's stylus is a product exclusively used for the defendant's position detector or not, and reached different decisions. While China and Korea found that the use of the defendant's stylus attaching it to an internal contact type position detectors is not economical or practical use, Japan pointed out that such a way of use still has some practical meaning. To the best of my understanding, the scopes of exclusive use type indirect infringement in China and Korea seem somewhat broader than that in Japan. Mr. Shigetomi, how do you consider from an attorney's point of view?
Okay, thank you for your question. I found that this issue is quite interesting. And however, as the counsel for a defendant in the mock trial, I'm somewhat embarrassed to see that the defendant's stylus was found to be a product exclusively used for the defendant's position detector, even though a defendant's stylus can really be used attached to the internal contact type position detector. I am wondering how judge would decide in case that the many of defendant's customers actually use the defendant's stylus with internal contact type position detector.
Okay, so let me ask the panelists about that matter. Judge Liu, please suppose that sufficient evidence shows that only less than 50% of the customers of the defendant use the defendant's styluses, attaching them to the defendant's position detectors. In such a case, do you still find the defendant's styluses are exclusively used for the defendant's position detectors?
Okay, thank you. In practice, how many percentage of the customers use the defendant's styluses attaching it to the defendant's position detector is an important reference factor to judge whether defendant's styluses is the exclusively used component. But in fact, the less than 50% of the customers to use the defendant's styluses attaching it to the defendant's position detectors doesn't mean that the defendant's stylus is not the exclusively used component. We still make the decision according to the Article 21 of the Interpretation 2 by the Supreme People's Court. Thank you.
Thank you, Judge Liu. Next, Korea. キム裁判官、
Judge Kim, so the defendant's stylus, the customers who use it on the defendant's detector, if it's less than 50%, the manufacture and sale of the stylus, would that constitute indirect infringement? My view is that defendant's stylus to be used for the internal contact type detector. So the ratio of that, I think, is important. So internal contact type detector, well, if the stylus is used more than 50% for such internal contact type, then I would say it's not exclusive use. However, if this stylus is attached to the detector, so it would not impact the final result, I think. So less than 50%. So if there are more people attaching it to the internal contact type, then it would not be infringement. I think that was mentioned. So if that ratio is high, or if the defendant's stylus would it be considered exclusive product? That I think is a difficult question. But what is your understanding at this time, if I may ask once again? My view is that the defendant's stylus to be, well, if 50% use it with internal contact type, or less than 50%, like 10%, I think that would be a difficult issue. Sorry to interrupt. Yeah, it's a very difficult issue, difficult question, I think. Maybe we ask India.
Does the percentage of customers using the defendant's position detectors in phone beta have any effect on your determining if the sales separately is just a trick to escape the allegation of infringement for the position detectors?
In my opinion, the answer would not change depending upon the number of customers using the stylus with the position detector. Even if 10% use it, it would be enough to hold infringement so long as the stylus is sold with the position detector. So the percentage itself will not make any difference in my view.
Thank you. Well, it becomes a very difficult question, but it seems that actual situation regarding the use of the involved product would not have much effect on the establishment of infringement itself. In other words, factors existing on the defendant's side are much more important than factors on customer's side. Mr. Hattori, do you have any question about this matter as an attorney?
Well, even factors regarding customers should not be overestimated. At the same time, if many customers use the defendant's styluses without attaching them to the defendant's position detectors, I would wonder if seeking an injunction against the manufacture and sale of the defendant's styluses completely would be the best solution or not. 小林裁判官はこの点についてどのように
Mr. Kobayashi, what do you think? What's your take on this issue? If the the percentage of the customers are using the percentage of the customers using this in the infringement is less than 50%, then in that situation it is impossible to see this, the establishment of the infringement. But I think it is important to pay more attention to the subjective understanding, subjective the intention. So if it is considered, the assumption here is that this is considered to be the indispensable for the solution of the subject. And so it is meant for the customers. And then in this situation, they have already made announcement and the notification to the defendant. Then just seeing the less than 50% of the users using this in the infringement form, it doesn't mean that this does not constitute the infringement. So this is the difficult. So maybe in the case of the damage compensation, this might have an impact for the amount of damages. Thank you very much. That was very instructive the comment. Thank you.
So as a Japanese attorney, I'd like to add one thing. In particular, I would like to point out the perspective of predictability. It will be a surprise for the defendant that the involved product is found as being used exclusively for the working of the patent invention, even if in the case that the many customers they actually use the involved product in a non-infringing way.
I agree with it. From an attorney's point of view, predictability is one of the most important values, especially as to patent litigations.
Predictability in an international context can be really a big issue. But now I would like to pick up another issue, the scope of injunction. Though relating to direct infringement, Justice Sen mentioned the scope of injunction. Justice Sen, could you please tell us more about the scope of injunction when the manufacture and the sale of the defendant's styluses and the defendant's position detectors constitute infringement? How would an injunction take effect? And how would violation of injunction be found?
Thank you, Nakajima-san. As I stated earlier, if the position detector is sold with the non-magnetic stylus, then it would be infringement. The injunction which is granted would in effect mean that if the stylus is sold as a standalone product, that is as a separate product, then it would not be infringement. The only way to determine this is to see how the defendant is selling it, maybe in the market or through brochures or other publicity material. And I also think that the plaintiff themselves would also be very active in the market and keep looking for how the defendant is selling the product. They may make a trap purchase, a trap order or a trap purchase to show that the defendant is selling it with the stylus. And also, if the defendant is recommending the stylus with the position detector, even then there could be infringement and the injunction will cover that kind of use. Thank you.
Thank you. Well, I would like to ask just one question to Judge Kim. Kim 裁判官、少し話は変わり
I'd like to change the topic slightly. In Korea, just recently, there has been the amendment of the law to include this non-exclusive use for the infringement. So could you tell us a bit more about it in Korea? There had been this amendment issue, but that was in 2019. On March 18, 2019, amendment to Article 127 of the Patent Act was submitted to the National Assembly. The amendment is designed to expand the protection of the patentee. I'm sorry. Yes, the amendment is designed to expand the protection of the patentee to remove the only requirement to allow indirect infringement by non-exclusive products and to expand the scope of indirect infringement to include non-physical objects such as electronic means. On the other hand, to avoid overly broadening the scope, it was limited to cases of intentional infringement. However, this has been discarded since this was the term for the assembly was ended. So at this moment, there has been some pros and cons, but I'm not quite sure of the actual status at this moment. Thank you very much.
Ask also to Judge Liu. Judge Liu, are there any discussions or specific movements to revise relative legal documents concerning indirect infringement of a patent right in China?
Sorry, I can't get your problem. Sorry.
Okay, so the similar question to Korea. Are there any discussions or specific movements to revise relative legal documents concerning indirect infringement of a patent right in China?
Could you speak a little loudly? Sorry.
Sorry. So I would like to ask again, is there any discussions to revise relative legal documents concerning indirect infringement of a patent right in China?
Yes, there are several cases every year, but not very much. Thank you.
Yeah, thank you very much. Okay, so I think it's time to wrap up this session. So, just a moment. Thank you. So, so to wrap up, それでは大高所長、これまで、
Well, Mr. Otaka, based on the exchange of views concerning indirect infringement, can you give us a wrap-up comment, please? Various views were presented. So even without laws about non-exclusive use under certain conditions, I think we share the view that we should find infringement, and the predictability and the protection, the balance between the two, I think that's something we need to think about. Thank you. Thank you for that. So not just for IP, but in cases dealing with specialized knowledge, you need to make a good use of expert knowledge. So in the second half, we're going to have a panel about the use of expert knowledge. We'll hear about the situations in each of the countries. And we will have a slide presentation during the break. We shall resume at 3:55, 5 minutes from now. And we'll start the second half from there. So we'll break at this time. Thank you.